Our courts should not be 50 votes to ramrod through legislation, and then next election cycle.
They're literally a fucking clout demon, dude. Trying to get a fucking deranged, mentally ill person clout right now. I get Elon Musk levels of hate, dude.
Pro tip for all left-leaning content creators: do legal research before giving arguments about this. Roe v. Wade is almost impossible to defend from a legal standpoint.
Will you actually argue against it?
Push for legislation. Thank you, Destiny, for existing, because at no point in my life do I ever feel like I'm overconfident now.
Wait, what? I don't know how I feel about the reading the source. I don't know how I feel about the way that they summarize this. I might bring on a few people to talk about this, okay? But people are gonna say that I'm a reactionary, and I hate it. People are gonna say I'm a fucking reactionary loser, all right? But based on all the emails I've gotten and all the conversations that I've had with lawyer people, Roe v. Wade was like an egregious overstep of judicial power. That basically, Casey v. Anthony, I think, and then Roe v. Wade, basically the courts, like, through this very complicated intersection of other things, like, fabricated this concept of right to privacy that doesn't exist legislatively. There is no law for this. They kind of like invented this from other like legal precedents, and then said from that, we're going to basically say that a state can't outlaw an abortion because of this hypothetical right to privacy that exists. But like, it's probably a dog shit ruling. And if you have a court that's not incredibly ideologically leaning towards one direction, like, from what I've heard, there's no way that that was going to hold up to scrutiny. Why did so many conservative justices agree with it over the years? I don't know how many times it was tested over the years. It might have been Planned Parenthood versus Casey. Also, I could be wrong. Maybe I've talked to really biased lawyers, and maybe it's all bullshit. I'll probably have I might have some lawyers tomorrow to talk about it, because it'd be interesting. But yeah, somebody messaged me and they asked me, like, what is the right to privacy? Like, the Supreme Court did not actually say that you can't make laws against abortion. I think what they said was that you have a fundamental right to privacy in the United States, and making laws against abortion violates that right to privacy. It's like, it's a very, very, very like out there. It's like a really weird out there way that they got to basically making it so abortion. But yeah, I don't know. Should Griswold? I don't know anything about the Griswold ruling. I'd have to go, but I'd have to read that up.
Return the issue of abortion of the people's elected representatives. We are literally fucking regressing. And it's going to happen under a democratic administration.
This was a big part of the Ketanji Brown Jackson hearings. Many Republican senators all knew about this case and shit, but they were asking about substantial due process a bunch. Yeah, like, the reality is that, like, if you want abortion to be federally... Oh, maybe it came from the Griswold case about contraception. If you want abortion to be federally protected, you have to... You have to legislate it. You need to codify it into law. That's probably the job of the legislative branch. And intuitively, I hate to use that word, and I probably shouldn't, but intuitively, we should probably know this. If we want abortion to be a protected right, that's probably something that should come from our legislative branch. It's probably not something that the courts should give us. It's probably not something we should get from an interpretation of existing law. We should probably have a law for it. But that's going to be difficult to do. I will say, however, if you want to find the silver lining in the horrible fucking crazy shit, okay, maybe it's good that the abortion got overturned, because maybe this is the kick Democrats need to rally up for the midterms, because right now I don't believe the midterms are looking good. So maybe this will energize some more voters, because with 50 members of the Senate, we're not passing fucking abortion legislation anytime soon. AOC's out here tweeting about fucking... She's out here tweeting about we need to, get rid of the filibuster. I don't think you'll have 50 votes. I don't know if you'll have 50 votes on the Democratic side for it. I don't think so, but who knows?
That's awesome. Now, for those of you who are freaking the fuck out, what does this mean? For red states, what this means is nothing is going to change. For blue states, what this means, nothing is going to change. Things are going to get much, much worse in red states, however.
Wait, what are you talking about? Wait.
Or freaking the fuck out. What does this mean? For red states, what this means is nothing is going to change.
I think he just misspoke, right? Or he had a stroke moment.
For blue states, what this means, nothing is going to change. Things are going to get much, much worse in red states, however.
Are you in favor of the filibuster? Yeah, I am, but liberals or progressives hate it when I say that. But I think the filibuster is totally fine. But I don't think our courts should not be 50 votes to fucking ramrod through legislation, and then next election cycle, 50 votes. Like, something is fundamentally broken with our Senate if we can't get 60 out of 100 people together to pass some fucking legislation. Okay, make the goddamn courts work. Jesus fucking Christ. All right. I would go a step further. I think the filibuster is based. You should have to get people together. You either, one, need a fuck ton of people elected, so you have massive popular support, or two, you should have to work with the other side a little bit to pass major legislation. I think the filibuster is a good thing in concept, but don't let Peace Go hear that or anybody, although people will shit on me for it and they hate that. So yeah, I don't know. But also, yes, we should bring back that you are forced to speak for the filibuster and no medical attention is allowed for the filibuster. So if you want to filibuster, you have to actually get up and do it. And if you collapse or whatever, nobody's allowed to help you up. If you can't get up, if somebody dies filibustering, then your filibuster session is over and the other side gets to vote and fuck you. So that's what I think. Why is Eris a deranged, mentally ill person?
Tell me this stuff. This person literally has TV in their name. They're literally a fucking clout demon, dude.
Oh, it's just because he probably sees her name and associates her with me. So he thinks that she's like a horrible person. Like it's literally that simple, I think.
What's wrong with you? Like, stop. You're a 21-month subscriber. You're a 21-month subscriber. Is that your favorite content creator? Is that why you're in here? Like, why? You're literally fucking trying to get a fucking deranged, mentally ill person clout right now off of saying psychotic shit.
What was her tweet about? Met Gala's happening again already, and this here stream is straight flexing. It's gilded glamour at a time when wealth inequality has passed gilded age levels. They've gone fully mask off. The funny, I can't tell. They must know. Hasan's fans must know. No, not a single one of Hasan's fans are under the delusion that he wouldn't have gone if he was invited, right? They must know that if he would have gotten an invite to that, he would have been there 1 trillion quadrillion %. Like, I wonder if he still would have been tweeting the same things. If the president is so bad, why has it basically not mattered for the last 40 years? Like, if it was that important, Dems would have legislated it into law at some point when they actually had congressional control. Well, passing legislation is hard. It's gotten harder to pass legislation like that, especially on socially divisive issues. Oh,
man. God. Therapy might help you learn to not internalize the criticism.
Uh-oh.
Dude, people who say your position of prominence comes with a target on your head, just brace it, enjoy the house and the car, your psychos are not unique and PR teams are used to this, don't realize that, like, no, that's not where this comes from. This is beyond the normal level of fucking hatred people get. I get Elon Musk levels of hate, dude.
Bro, are you serious? I'm pretty sure like half the country still has no idea who the fuck you are. Like, even though Twitch is big and we have gotten like, well, I say I'm not on Twitch, but like, even though streamer has grown, bro, I'm pretty sure more people know and hate Elon than even know you exist. Jesus.
What do I do? What have I done that deserves Elon Musk levels of hate? People act like I'm Jeff Bezos, dude. People act like I'm literally just as bad as Jeff Bezos. Like, that's the fucking crazy thing.
You think lefties wouldn't want to pursue abortion legislation if they saw a chance? They're mourning Roe v. Wade, not because they think it was a well-founded piece of law, but because it was kind of a federal stopgap against red state abortion laws. Part of their argument is the fact that it was a necessary law. in lieu of legislation. I think we're in a really dangerous, we're talking about process now. I mean, like, I think abortion is really important. It should be legal in the United States.
Steven.
Obviously. If your action being overturned is that you are ready to vote, you're a pathetic loser. What's the alternative, you dumb fuck? God, what a fucking loser. He's like 5 degrees away from even being impacted by this. 1, he's not a woman, and 2, he's never touched a fucking woman. So why the fuck would we give a fuck what your opinion is about anything having to do with this? God, what a fucking loser. Oh God, I hate him so much. The reason why Roe v. Wade has gotten overturned is because he lost the 2016 election. Does anybody know how does anybody know how our process works? Do you guys know where the government comes from? Do we know this? Push and pee, push and pee. You have a president. He takes a judge and he puts it in front of Congress, namely the Senate. And then they go thumbs up or thumbs down. And then he goes into the Supreme Court. And then the Supreme Court interprets the laws that we get from Congress. That's how it works. When Donald Trump, when Donald Trump was president, he got to nominate it was three, right? This motherfucker got 3 judges. What the fuck? 3 judges. The Senate confirmed them, and now they're in the Supreme Court. And now, you know what? No more abortion. Gone. Gone.
All right, somebody who's not a pro tip for all left-leaning content creators: do legal research before giving arguments about this. Roe v. Wade is almost impossible to defend from a legal standpoint.
Will you actually argue against it?
Push for legislation. I don't know about you, chat, but I like to go to hard stuck diamond League of Legends, or hard stuck plat, hard stuck whatever, gold League of Legends streamers for my legal takes. Oh, I'm sorry. Justice Sotomayor, Justice Kagan, you are not legally trained. I'm sorry. It's impossible to defend according. Omniliberal had something to say. What an absolute total dullard. Like, how can he, like, I can't even get mad at that guy. He's so, like, honestly, I want to say thank you. Thank you, Destiny, for existing, because at no point in my life do I ever feel like I'm overconfident now. Like, if he can post, and with the verve and vigor that he posts, you never have to feel insecure. I think his posts are so bad, they cured that. I mean, he's a guy who got his he's got his last Twitter account banned because he tried to take an LSAT on stream and he did so poorly that he like trended. So many people were laughing at him for failing the LSAT that it trended, and then people were like, "Oh, it's a ban evasion account."
Get some new lore.
There's a tweet about that. D-Fans mass reported me.
Oh, did D-Fans mass report my tweet? Oh no! Did D-Fans mass report my tweet? Oh no!
Guess what? He's stupid. Should he go back to? He needs to go back to like D Live or wherever else they accept.
Okay, I might bring on Pisco or somebody else to flesh out more of like the legal arguments, but I think the biggest problem with Roe v. Wade was that it came from, I think there was a prior decision, Griswold versus some bullshit, but basically there was a weird way that the Supreme Court kind of fabricated this idea of like right to privacy, and then from that, like, we got like abortion. But like when you have like essential parts of your social values that are kind of like held together by like a Supreme Court decision, I think it's probably not good. Oh, was it Griswold versus Connecticut? I think that it's really scary if you're relying on having like a liberal court when really you should. I think if you say that to a Supreme Court justice, they'll probably stab you in the eye because they're not supposed to be viewed that way. But like if you have like essential things that are held up by only having, you know, like some justices on the Supreme Court that are you hope are of like a certain ideological leaning, probably not a good place to be in. But I think we talked about this, I think was it a year ago, several months ago, that the Roe v. Wade stuff was always kind of like skirting on thin ice, but DSP fucking did it. Oh my God. Did we miss it? Griswold was the contraceptives one, then 8 years later, Roe was the privacy meme. I thought Griswold is what gave us that privacy thing originally, though, and then Roe v. Wade built on it. Or used that basically as precedent. That was my thought. I need to read this more. I wouldn't feel comfortable arguing about this, but I used to think Roe v. Wade was fine, and then like every single time I was ever linked, I got emailed a ton. Anytime, or like a lawyer would email me, anytime I got linked to like a legal blog or like a legal scholar like talking about it, it seemed like way more flimsy than I had originally thought. And I don't think it might be that there are good actually, maybe my tweet is too strong. Maybe there are really good legal defenses of Roe v. Wade. I'm just not aware of them. And then I don't know if it was Pisco or other people, but there was a lot of people were worried that if Roe v. Wade was tested, that it would almost certainly fall on a conservative court because it's so impossible to imagine that anybody would defend it. You know, something like that. And every Dem senator just believed Gorsuch, Kavanaugh, and Barrett when they said they wouldn't strike it down and voted yes. Wait a second. Is this actually true? Because my understanding is that Supreme Court justices, when they're being interviewed, are very reluctant to answer how they would rule on something. I thought justices get triggered as fuck. Like when you're doing a Senate confirmation hearing or whatever, and you're like, would you rule on this or that? I thought generally justices like, fuck you, I'm not going to tell you how I would rule. That's not part of what I do. I thought, did all three of these justices say that they wouldn't strike down Roe v. Wade? I would be really shocked if that was the case. It might be the case, but I would be shocked if that was the case. Should gay and interracial marriage rights be rolled back too? In the leaked opinion, they list Ubergefell and Loving as examples of other incorrect rulings. Quite a no purview to rule on. I would have to be more familiar with those rulings. I think that the conversation here, the problem is there's two different conversations. On one end, like we can talk about the actual social issues, which I think are important to talk about. But then on the other, we have to have like, I think, a philosophical discussion on like, what is the role of government? But I mean, like, I don't think anybody really cares about that conversation. I don't like, I don't know. I like legislation, but someone's wrong in the opinion. They literally say they're not reaching gay marriage or contraception or strict limited option to or opinion to abortion. Okay, we should just actually read it, but the issue is very muddied by the politicization of the court. Yeah, I actually there was only one suggestion that I saw regarding the Supreme Court that I really liked, and it was something like there should be two new Supreme Court justices like every 14 years or something, or like once every like 14. There was some number, but basically the way that it worked out was it was guaranteed that like every president would get to nominate one Supreme Court justice or something, or like every other one would. The idea of like a politicized Supreme Court is really scary. I would like to think that in general, the Supreme Court doesn't act in a highly politicized manner. I mean, all the justices would say that, and they would fight to the death to say that. But I mean, obviously people will have their ideological leanings a bit, but that their ideological leanings should be like ideologically, like how do they interpret the Constitution, or what is their job? Not like, are they a Republican or a Democrat, ideally, right? Who do you think leaked it? I don't know, but I'm pretty sure they'll find out, right? There's like only a few people in the world that would have had access to this draft. Like, abortion presents a profound moral issue on which Americans hold sharply conflicting views. Some believe fervently that a human person comes into being at conception and that abortion ends an innocent life. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body, prevents women from achieving full equality. Still others in a third group think that abortion should be allowed under some, but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. For the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens. Then, in 1973, this court decided Roe v. Wade How would you say this? Is it like case 410 Supreme Court 113 or what? I don't even know what. I don't know how you do this, but it couldn't be case 410. 410 US 113. How do you say this? I don't even know what these numbers mean. I'm gonna be honest with you. Link to the oral arguments. What? Oh, for about 2 hours. Okay. Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that American law or the common law had ever recognized such a right, and its survey of history ranged from the constitutionally irrelevant, e.g., its discussion of abortion in antiquity, to the plainly incorrect, e.g., its assertion that abortion was probably never a crime under the common law. After cataloging a wealth of other information having no bearing on the meaning of the Constitution, the opinion concluded with a numbered set of rules much like those that might be found in a statute enacted by a legislature. Under this scheme, each trimester of pregnancy was regulated differently, but the most critical line was drawn at roughly the end of the second trimester, which at the time corresponded to the point at which a fetus was thought to achieve viability. Oh man, wait, hold on. Where is peace? I don't actually know the rulings. I'll be honest with you, I don't know the original rulings. In Roe v. Wade, do they actually discuss like different regulations regarding the different trimesters? Is that actually true? We should just read like the original Roe v. Wade. They discuss different things that would be acceptable, yes. Oof. Why would that matter if it was just a privacy thing though? That feels like even more like legislatively done then. Ugh. Or maybe not, maybe I'm a dumb fuck, who knows? Yikes, I don't know. Or that might have come from the Casey case as well, maybe. Roe v. Wade covered up to the second trimester. Yeah, interesting. Okay. I mean, I'm assuming they wouldn't lie. The justices wouldn't lie when talking about prior rulings as well, right? Under this scheme, each trimester of pregnancy was regulated differently, but the most critical line was drawn at roughly the end of the second trimester, which at the time corresponded to the point at which fetuses were thought to achieve viability, such as the example to survive outside of the womb. Although the court acknowledged that states had a legitimate interest in protecting potential life, it found that this interest could not justify any restriction on previability abortions. The court did not explain the basis for this line, and even abortion supporters have found it hard to defend Roe's reasoning. One prominent constitutional scholar wrote that he would vote for a statute very much like the one the court ended up drafting if he were a legislator, but his assessment of Roe was memorable and brutal. Roe was not constitutional law at all and gave almost no sense of an obligation to try to be. Pre-viability, not previability, pre-viability? Okay. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to that decision, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. It imposed the same highly restrictive regime on the entire nation, and it effectively struck down the abortion laws of every single state. As Justice Byron White aptly put it in his dissent, the decision represented the exercise of raw judicial power. And it sparked a national controversy that has embittered our political culture for a half century. Eventually, in Planned Parenthood of Southeastern Pennsylvania versus Casey, 5 blah, 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 the court revisited Roe, but the members of the court split 3 ways. 2 justices expressed no desire to change Roe in any way. 4 others wanted to overrule the decision in its entirety, and the 3 remaining justices, who jointly signed the controlling opinion, took a third position. Their opinion did not endorse Roe's reasoning, and it even hinted that one or more of its authors might have reservations about whether the Constitution protects a right to abortion. But the opinion concluded that the stare decisis? What is this, prior decision? I don't know what this means. Hold on. The legal principle of determining points in litigation according to precedent. Okay, so prior, yeah. So prior decisions, basically. Which calls for prior decisions to be followed in most instances required adherence to what it called Roe's central holding, that a state may not constitutionally protect fetal life before viability, even if that holding was wrong. Anything less, the opinion claimed, would undermine respect for the court and the rule of law. Paradoxically, the judgment of Casey did a fair amount of overruling. Several important abortion decisions were overruled in toto, and Roe itself was overruled in part. Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin under which states were forbidden to adopt any regulation that imposed an undue burden on a woman's right to have an abortion. The decision provided no clear guidance about the difference between a due and an undue burden. But the three justices who authored the controlling opinion called the contending sides of a national controversy to end their national division by treating the court's decision as the final settlement of the question of the constitutional right to abortion. As has become increasingly apparent in the intervening years, Casey did not achieve that goal. Americans continue to hold passionate and widely divergent views on abortion, and state legislatures have acted accordingly. Some have recently enacted laws allowing abortion with few restrictions at all stages of pregnancy. Others have tightly restricted abortion beginning well before viability. And in this case, 26 states have expressly asked this court to overrule Roe and Casey and allow the states to regulate or prohibit pre-viability abortions. Before us now is one such law. The state of Mississippi asks us to uphold the constitutionality of a law that generally prohibits an abortion after the 15th week of pregnancy, several weeks before the point at which a fetus is now regarded as viable outside the womb. In defending this law, the state's primary argument is that we should reconsider and overrule Roe and Casey, and once again allow each state to regulate abortion as its citizens wish. On the other side, respondents of the Solicitor General ask us to reaffirm Roe and Casey, and they contend that the Mississippi law cannot stand if we do so. Allowing Mississippi to prohibit abortion after 15 weeks of pregnancy, they argue, would be no different than overruling Casey and Roe entirely. They contend that no half measures are available and that we must either reaffirm or overrule Roe and Casey. We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one in which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such rights must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. Imagine your last name is Glucksberg. Jesus. The right to abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right that the court has held to fall within the 14th Amendment's protection of liberty. Roe's defenders characterized the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledged, because it destroys what those decisions called fetal life, and that the law, and what the law now before us describes as an unborn human being. Okay, so this is kind of good, I guess, because people were worried that interracial marriage, contraceptives, and I guess sodomy would be. Have people been saying that? I thought people were saying that in chat. But Alito's writing here seems to go on to say that those things are fundamentally different from abortion, which is probably good, right? No, it's still undermined, is it? Okay, maybe we'll keep reading, I guess, but... he specifically writes that like 4 times. None of that is up for grabs, according to VP Walt. But Pisco says it's still undermined. You're an idiot if you think it's not. Because that's where the logic of the opinion leads you, obviously. Well, how, Pisco? Aren't they saying that it's fundamentally different because we're dealing with like a fetal life versus other like private matters? Well, I don't know. I don't care, actually. Let's just keep reading. All those cases stem from the concept of substantive due process. Yeah, but the argument that Alito is making here is that all of those other cases are fundamentally different from the one regarding fetal life, right? How do you pronounce this? Is it stare decisis or... They are attacking the underlying reasoning of the right to privacy. I wholesale reject that. I don't think that's true at all. But we'll see. Hold on. I'll keep reading. I need to keep reading.
Stare decisis has been
Stare decisis. Okay. Stare decisis, the doctrine on which Casey's controlling opinion was based, does not compel unending adherence to Roe's abuse of judicial authority. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement on the abortion issue, Roe and Casey have inflamed debate and deepened division. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved like most important questions in our democracy by citizens trying to persuade one another and then voting. That's a quote from, I guess, Scalia, part of the dissenting opinion of the case. This is what the Constitution and the rule of law demand. The law at issue in this case, Mississippi's Gestational Age Act, see blah, 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 contains this central provision. Except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. To support this act, the legislature made a series of factual findings. It began by noting that at the time of enactment, only 6 countries besides the United States permitted non-therapeutic or elective abortion on demand after the 20th week of gestation. The legislature then found that at 5 or 6 weeks gestational age, an unborn human being's heart begins beating. At 8 weeks, the unborn human begins to move in the womb. And I don't know, do we care about this? Found that most abortions after 15 weeks employ dilation and evacuation procedures which involve the use of surgical instruments to crush and tear the unborn child, and concluded that the intentional commitment of such acts for non-therapeutic or elective reasons is a barbaric practice, dangerous for the maternal patient, and demeaning to the medical profession. Respondents are an abortion clinic, Jackson Women's Health Organization, and one of its doctors. On the day the Gestational Age Act was enacted, respondents filed suit, federal district court, against various Mississippi officials, alleging that the act violated the court's precedents establishing a constitutional right to abortion. The district court granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, reasoning that viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions, and that 15 weeks gestational age is prior to viability. The Fifth Circuit Court affirmed. We granted certiorari. Certiorari. We granted certiorari to resolve the question whether all pre-viability prohibitions on elective abortion are unconstitutional. Petition is primary defense. Okay. We begin by considering the critical question whether the Constitution, properly understood, confers a right to obtain an abortion. Skipping over that question, the controlling opinion in Casey reaffirmed Roe's central holding, based solely on the doctrine of stare decisis, right? But as we will explain, proper application of stare decisis requires an assessment of the strength of the grounds on which Roe was based. See infra bullshit. We therefore turn to the question that the Casey plurality did not consider, and we address that question in 3 steps. First, we explain the standard that our cases have used to determine whether the 14th Amendment's reference to liberty protects a particular right. Second, we examine whether the right at issue in this case is rooted in our nation's history and tradition, and whether it is an essential component of what we've described as ordered liberty. Finally, we consider whether a right to obtain an abortion is supported by other precedents. Constitutional analysis must begin with the language of the instrument, Gibbons v. Ogden, blah, 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 which offers a fixed standard for ascertaining what our founding document means. The Constitution makes no express reference to a right to obtain an abortion, and therefore those who claim that it protects such a right must show that the right is somehow implicit in the constitutional text. Roe, however, was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. And that privacy right, Roe observed, had been found to spring from no fewer than 5 different constitutional provisions. See the 1st, 4th, 5th, 9th, and 14th Amendments. The court's discussion left open at least 3 ways in which some combination of these provisions could protect the abortion right. One possibility was that the right was founded in the 9th Amendment's reservation of the rights to the people. Another was that the right was rooted in the 1st, 4th, or 5th Amendment, or in some combination of those provisions, and that this right had been incorporated into the Due Process Clause of the 14th Amendment, just as many other Bill of Rights provisions had by then been incorporated. And a third path was that the 1st, 4th, and 5th Amendments played no role, and that the right was simply a component of the liberty protected by the 14th Amendment's Due Process Clause. Roe expressed the feeling that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution, and that specifying its exact location was not of paramount importance. The Casey court did not defend this unfocused analysis, and instead grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's Due Process Clause. We discuss this theory in depth below, but before doing so, we briefly address one additional constitutional provision that some of respondents, amici, I've been under the impression that Roe v. Wade has been tested so many times over the years that it basically became impossible to overrule. Has Roe v. Wade ever been tested in court? I don't know, actually. I don't know if it's been if those cases have gone before the Supreme Court or if they just get shot down in like lower circuit courts. I don't know. I'm not sure. Singular is amicus. Oh, so this is amici? I'm not going to find out how to pronounce this. 1992 in the Casey case, Planned Parenthood v. Casey. Yeah, but besides that, like nothing else. It's not like there've been like hundreds of cases, or even like 5 before the Supreme Court where they're all like, yes, abortion is affirmed or whatever, right? There was one just a few years ago. It was constantly upheld up until now. All other cases have been through the lens of Casey. Roe v. Wade has always gone before the court on abortion grounds through 1992. Casey. All other cases have been through the lens of Casey. Okay. You never pronounce a C like an S for Latin phrases. Okay. Where were we at? We discussed this theory in depth below, but before doing so, we briefly address one additional constitutional provision that some of respondents, amici, have now offered as yet another potential home for the abortion right, the 14th Amendment's Equal Protection Clause. See brief for the United States, blah, 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 blah. Neither Roe nor Casey saw fit to invoke this theory, and it is squarely foreclosed by our precedents, which establish that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. The regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless the regulation is a mere pretext designed to effect an individuous discrimination against members of one sex or the other. And, as the court has stated, the goal of preventing abortion does not constitute invidiously discriminatory animus against women. Jeez, okay. Amici. Gotcha. Amici? Chill, Jesus. Accordingly, laws regulating or prohibiting abortion are not subject to the heightened scrutiny. Rather, they are governed by the same standard of review as other health and safety measures. Do I need to explain this? Or do we follow along? Should I read this? I kind of want to read this whole thing just so we know, because I feel like this is going to be a big deal for the next week or two. But I guess it's up to you guys. Should we read this? Yes or no? It's like 60 pages, but I don't think it's that bad. These are pretty short. It's like Harry Potter pages. I guess I'll just try to talk about what I think are the important parts. So for people trying to say that equal protections is what's invoked here, you can't outlaw abortion because it's just for one, because it's just for like one sex. The court is arguing that the only time you would trigger the equal protections clause is if you have like a surgery that is, if you have surgeries against like only men or women that rise to this level of like invidiously discriminatory, which invidiously, I've never used this word. I've never heard this word. Yeah, so basically just like if it's like a surgery that is like highly targeting somebody that would fuck somebody over, I guess, or seems, I guess, like discriminatory in nature, I feel like you might be able to argue that abortion... No, probably not. No, actually, no, you wouldn't. No, because people would say that like we don't want to make abortion illegal because we hate women. We want to make abortion illegal because we want to protect fetuses, right? Now maybe if everybody was saying like fuck women, make abortion illegal, then maybe it would rise to that level. But that, like, it's not like people are just like we want to fuck women over by banning abortion, right? Yeah. I remember a while back Destiny was saying that Roe v. Wade didn't make sense. Wish I could find a clip. Yeah, find it, because we got 100% accurate DGG analyst desk predictions here. Okay. But, okay, we're going back. That's why the standard matters. If it was just a reasonable basis, you can't look deeper into what the real motives might be. Sure. Okay. One thing that also won't be talked about that is kind of sad is that my understanding is I think this is literally the first time that this has ever happened in the history of the court. Rational basis, not reasonable basis. Okay. Wait, P. Walt, are you a lawyer? Because if you are, you should have a lawyer for that, you dumb fuck. I just based on like the little bit I've read, Supreme Court justices get really, really ass mad when it comes to like politicization of the courts and like breaking the process and shit. And I'm pretty sure it's not. Wait, really? It is the first time a draft has been leaked. Okay, Nico, you're overruled by Esports Batman, who has a lawyer flair. So, but yeah, I think this is like literally the first time this has ever happened that a draft has leaked like this before, which is pretty bad. Okay, I'm a law student too. No, law student is enough, dumb fuck. Do you think it was done to try and affect the ruling? I mean, it won't, right? I can't foresee that any of the justices like redoing their opinions, but I mean, like, the league was probably political in nature, right? If we're being honest, probably. Maybe. No, probably. Almost certainly, right? Yeah. But okay, stop. Let me keep reading. We're wasting a lot of time. Fuck. I'm gonna have to start my debate in an hour, so we're not even gonna get through this. The underlying theory on which this argument rests. What I'm going to do is... Okay, sorry. Okay. The underlying theory on which this argument rests, that the 14th Amendment's Due Process Clause provides substantive as well as procedural protection for liberty, has long been controversial. But our decisions have held that the Due Process Clause protects two categories of substantive rights. The first consists of rights guaranteed by the first 8 amendments. Those amendments originally applied only to the federal government. But this court has held that the Due Process Clause of the 14th Amendment incorporates the great majority of those rights and thus makes them equally applicable to the states. The second category, which is the one in question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the court has long asked whether the right is deeply rooted in our history and tradition, and whether it is essential to our nation's scheme of ordered liberty. And in conducting this inquiry, we have engaged in a careful analysis of the history of the right at issue. Justice Ginsburg. No, it's Ginsburg. Justice Ginsburg's, it is Ginsburg, right? Wait, am I crazy? It's Ginsburg. It is, I'm 99% sure it's Ginsburg. Every time I used to read, I think it's Antonin Scalia. Sometimes I would read his name as Scalia. Antonin Scalia. Okay. Justice Ginsburg's opinion for the court in blah, blah, blah is a recent example. In concluding that the Eighth Amendment's protection against excessive fines is fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition. Her opinion traced the right back to Magna Carta, Blackstone's commentaries, and 35 of the 37 state constitutions in effect at the ratification of the 14th Amendment. A similar inquiry was undertaken in McDonald Supra, which held that the 14th Amendment protects the right to keep and bear arms. The lead opinion surveyed the origins of the Second Amendment, the debates in Congress about the adoption of the 14th Amendment, the state constitutions in effect when the amendment was ratified, at least 22 of the 37 states protected the right to keep and right to bear arms, federal laws enacted during the same period, and other relevant historical evidence. Only then did the opinions conclude that the framers and ratifiers of the 14th Amendment counted the right to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. Can we fact check that? Yeah, where's our PolitiFact thing on Alito's fucking draft? Timms and McDonald concerned the question whether the 14th Amendment protects rights that are expressly set out in the Bill of Rights, and it would be anomalous if similar historical support were not required when a putative right is not mentioned anywhere in the Constitution. Thus, in Glucksberg, which held that the Due Process Clause does not confer a right to assisted suicide, the court surveyed more than 700 years of Anglo-American common law tradition.
Obama.
True. And made it clear that this fundamental right must be objectively deeply rooted in this nation's history and tradition. Historical inquiries of this nature are essential whenever we are asked to recognize a new component of the liberty protected by the Due Process Clause, because the term liberty alone provides little guidance. Thanks, Founding Fathers. Liberty is a capacious, I believe, term. As Lincoln once said, we all declare for liberty, but in using the same word, we do not all mean the same thing. Oh. That wasn't funny, I'm sorry. In a well-known essay, Isaiah Berlin reported that historians of ideas had cataloged more than 200 different senses in which the terms had been used. In interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what the amendment protects with our own ardent views about the liberty that Americans should enjoy. This is why the court has long been reluctant to recognize rights that are not mentioned in the Constitution. Collins v. Harker Heights, blah, blah, blah. Substantive due process has at times been a treacherous field for this court, and it has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives. As the court cautioned in Glucksberg, we must exercise the utmost care whenever we are asked to break new ground in this field, lest the liberty protected by the Due Process Clause be subtly transformed into the policy preferences of the members of this court. On occasion, when the court has ignored the appropriate limits imposed by respect for the teachings of history, it has fallen into the freewheeling judicial policymaking that characterized discredited decisions such as Lochner v. New York. The court must not fall prey to such an unprincipled approach. Instead, guided by the history and tradition that map the essential components of our nation's concepts of ordered liberty, we must ask what the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. It's kind of cute when you write a doc like that. Like, this is basically like Alito's like anti-abortion manifesto, right? He's like debating the whole internet on, and he's got sources and everything. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero. None. Wow. Dramatic. Nice writing. We see those staffers working overtime. No state constitutional provision had recognized such a right. Actually, if it was a staffer, we would have had a new paragraph for each of these two words. It would have been based. No state constitutional provision had recognized such a right. Until a few years before Roe was handed down, no federal or state court had recognized such a right, nor had any scholarly treatise of which we are aware. And although law review articles are not reticent about advocating new rights, the earliest articles proposing a constitutional right to abortion that had come to our attention was published only a few years before Roe. Not only was there no support for such a constitutional right until shortly before Roe, but abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time of the adoption of the 14th Amendment, 3/4 of the states had made abortion a crime at any stage of pregnancy, and the remaining states would soon follow. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. It is therefore important to set the record straight. Holy shit, he's a DGG'er! Clearing up some misconceptions. I'm surprised the leader didn't push this in a fucking twit longer. We begin with the common law, under which abortion was a crime at least after quickening, i.e. the first felt movements of the fetus in the womb, which usually occurs between the 16th and 18th week of pregnancy. Quickening, the quickening. Where have I heard that term before? I feel like this is like a sci-fi or... Am I crazy? Where have I heard this term before? People are saying Highlander. I don't know if I've ever seen that show or movie before. What? What is Pisco's opinion on this? People are, or esports Batman. People are blaming the draft Supreme Court ruling on Trump. But to be fair, I'm pretty sure Hillary/Bernie would have also appointed Gorsuch. Wait, this is a troll tweet, right? He's trolling.
The American people are tired of women.
Oh, wait, now I don't know. Maybe he's being true. No, okay. It's a troll tweet. Okay, close call. Close call, guys. I think I can see an argument if we were going to the road, maybe for Gorsuch, but Kavanaugh and Barrett, no shot. I think most people, if I remember correctly, I thought most legal people were okay with Gorsuch. It seemed like an okay-ish thing for like what Trump could have nominated. But I thought that Kavanaugh and Barrett were. Kavanaugh was one of the George W. Bush lawyers during the Bush v. Gore case. Damn. They would have nominated Garland again 100%. Yeah, probably. Yeah, of course. I'm sorry. Yeah, that we lost under Obama. Yeah, for sure. The eminent common law authorities all describe abortion after quickening as criminal. Henry de Bracton's 13th century treatise explained that if a person has struck a pregnant woman or has given her poison, whereby he has caused an abortion, if the fetus be already formed and animated, and particularly if it be animated, he commits homicide. Sir Edward Coke's 17th century treatise likewise asserted that abortion of a quick child was murder if the child be born alive, and a great misprison if the child dieth in her body. Two treatises by Sir Matthew. Do we really need to read all of these? But two treatises by Sir Matthew described abortion of a quick child who died in the womb as a great crime, and it's just gonna go through. So it sounds like if we're talking about the if we're trying to invent.
I got muted for saying Obama.
Now I have become Obama himself.
What the fuck?
if we're trying to invent new rights guaranteed by the Constitution or infer them from other things like the 14th Amendment, it sounds like what the court wants to do, what Alito is saying, is the court ought to be looking historically to see if like such a right is found in the tradition and history of our country, basically. So now they're reviewing, well, let's go ahead and survey then when the 14th Amendment was made or prior to this, like, is there any like tradition or history around the world that shows a strong support for abortion laws, basically. Was it really necessary to list every fucking document about anti-abortion? Jesus Christ. Well, yes, for the reason that I just listed, right? Because when the court issues an opinion. So one thing that's crucial in the eyes of the court and the government and anybody that cares about this, which is like nobody, but a crucial thing for the Supreme Court is that when they're having debates or arguments, their opinion has to be well-founded historically, and it has to be well-established. The argumentation needs to be rock solid, because you can't have the Supreme Court constantly doing one thing, then another, then another, then another, because eventually the court will undermine itself. So like the court flipping over like old rulings is seen negatively in the eyes of both the court and the rest of the government, because it makes the Supreme Court look like flimsy, like yeah, there's a better word I'm looking for. Inconsistent, I guess. Yeah. Destiny. Yeah, but this is also a bit cherry picking because you could do a survey of reproductive rights and privacy and come to the opposite conclusion. Could you though, esports Batman? If that's true, then I imagine that the onus would be on the people. Well, actually, we would probably see that in the dissenting document. I don't know if you would call it a brief, the dissenting opinion, or the arguments here should have been made before the court during the oral arguments. I imagine there are submitted written arguments as well, right? We might listen to this later. 2 hours. Fuck, I'm not going to be able to listen to all this today. Through the 19th century is seen as a time of more restrictive sexual mores. Abortion was actually common. According to at least one estimate, 1 in every 5 women at the time had an abortion. Wait, what? That sounds really, really, really high. But I don't know. I don't know how I feel about the reading the source. I don't know how I feel about the way that they summarize this. Common reference to menstrual abnormality.
This article might be interesting, but not as interesting as our...
Thank you. Common reference to menstrual abnormalities, dysfunctions, and blockages or obstructions in historical sources suggest that folklore dictated that women would be restored to balance if the obstruction was removed by herbal remedy. Most people in the 19th century believed that women were especially susceptible to uterine abnormalities that needed treatment. A woman's awareness of quickening indicated a real pregnancy. Some have estimated that between 20 to 35% of 19th century pregnancies were terminated as a means of restoring menstrual regularity. So, but does this mean they knew they were having abortions, or did they just think there was an irregularity that they were fixing? Because that makes it sound like they just thought there was an irregularity they were fixing. Rather than like that. It was probably including medically necessary. Yeah. Because what the Supreme Court here is talking about pretty explicitly is like, I think they used the term, was it therapeutic abortion or something? But the article is saying it's creating sure, but okay. All right, hold on. I don't want to read every side argument right now, but fuck, I'm not gonna have time to finish reading this. Sir Edward Coke's 17th century treatise likewise asserted that abortion of a quick child was murder if the child be born alive, and a great misprison if the child died in her body. We read this, blah, blah, blah. English cases dating all the way back to the 13th century corroborate the treaty's statements that abortion was a crime. See this and that and that. In 1732, for example, Eleanor Baer was convicted of destroying the fetus in the womb of another woman and thereby causing her to miscarry. For that crime and another misdemeanor, Baer was sentenced to 2 days in the pillory and 3 years imprisonment. Although a pre-quickening abortion was not itself considered homicide, it does not follow that abortion was permissible at common law, much less than abortion was a legal right. Although a pre-quickening abortion was not itself considered homicide, it does not follow that abortion was permissible at common law, much less that abortion was a legal right. Washington v. Glucksberg, removal of common law, did not represent. Quite to the contrary, in the 1732 case mentioned above, the judge said of the charge of abortion, with no mention of quickening, that he had never met with a case so barbarous and unnatural. Similarly, an indictment from 1602, which did not distinguish between a pre-quickening and post-quickening abortion, described abortion as pernicious and against the peace of Our Lady the Queen, her crown and dignity. That the common law did not condone even pre-quickening abortions is confirmed by what one might call a proto-felony murder rule. Hale and Blackstone explained a way in which a pre-quickening abortion could rise to the level of a homicide. Hale wrote that if a physician gave a woman with child a potion to cause an abortion and the woman died, it was murder because the potion was given unlawfully to destroy her child within her. As Blackstone explained to be murder, as Blackstone explained to be murder, a killing had to be done with malice aforethought, either express or implied. In the case of an abortion, as Blackstone wrote, the law will imply malice for the same reason that it would imply malice of a person who intended to kill one person accidentally killed a different person. If one shoots at A and misses him but kills B, this is murder because of the previous felonious intent which the law transfers from one to the other. The same is the case where one lays poison for A and B, against whom the prisoner had no malicious intent, takes it and it kills him. This is likewise murder. So also, if one gives a woman with child a medicine to procure abortion and it operates so violently as to kill the woman, this is murder in the person who gave it. I don't know how I feel about that argument. That seems weird as fuck, but okay. No, I guess that does make sense. That's kind of weird, but... No, wait, does it? If I go to remove a kidney, and in removing the kidney I accidentally kill you, for that to be murder... Maybe. Yeah, you would have to assume the abortion murder because it's transferred. Yeah, okay.